Hi, I'm firearms attorney Gilbert Ambler, and today we're back to talk about Virginia's assault on assault firearms and lessons that apparently were not learned back in 2020, the last time Virginia tried this exact same type of restrictions. Before we dive into this subject, as always, if you have not yet hit that subscribe button, go ahead, hit subscribe for us. Like, comment with your thoughts, and share with your friends. That way you and your friends can keep getting this important Second Amendment related content. What we're going to be talking about is a number of bills that have been filed in Virginia that would restrict firearms rights. We're going to talk about why they are concerning. We are also going to talk about why they're probably not going to pass, but we all need to keep an eye on them. And then we're finally going to talk about if they do pass, the likelihood that a court will strike them down, which I think is actually very likely with respect to many of these bills. Now, there's been a bunch of bills that are negative with respect to firearms. If you go to Virginia Citizens Defense League, you can check out their website. They've got a legislation tracker that will help you keep track of what has been proposed. We're going to focus on ones that would restrict what has been called assault firearms, and we're going to focus on a law that would restrict the carrying of a firearm in any restaurant that serves alcohol. Let's start with the new shifting definition of assault firearm. Assault firearm is a term that is currently used in the law in Virginia, but it really has very limited impact. It applies only to weapons that are equipped at the time of the offense with a magazine capable of holding over 20 rounds, and there's exemptions for people that have their concealed handgun permits. It doesn't affect your ability to own. It affects your ability to carry if you don't have a concealed handgun permit, those weapons, and only then in certain jurisdictions. This definition comes from 18.2-308.2:2 of the Virginia Code. They are expanding this definition, and there is a proposed expansion of this definition. Everything I'm talking about today is proposed. Again, looks fairly unlikely to actually pass, but we're going to talk about what would happen if it did pass. The proposal, though, would expand this definition to include most commonly owned firearms. So it's going to affect both firearms rifles and everything that they've done is only for centerfire weapons. For whatever reason, they don't seem to care about 22s, don't care about rimfire weapons. Centerfires only. I'm not even sure if the politicians proposing this stuff understand the difference between centerfire and rimfire weapons. With respect to centerfire rifles, if it has a fixed magazine with a capacity of over 10 rounds, it's going to be called an assault firearm. If it has a detachable magazine, centerfire rifle, and has any one of the following features, and they list a whole number of features. These are the common things that you often see: telescoping or collapsing or expanding stocks, folding stocks, threaded muzzle so that it could accept a suppressor or a flash hider, attachments for grenade launchers or flare launchers. But some of the more concerning ones: any pistol grip that protrudes below the firearm. So your common AR pattern or AK pattern rifles, they're going to be affected by this. Even more concerning is if the rifle has a second grip for the non-trigger hand. Now, they don't say a shroud, a barrel shroud, but a second grip. And the question to me is the foregrip on a rifle a second grip? I think the foregrip probably is a second grip. Now, keep in mind, most barrel shrouds that keep you from burning your hand might be viewed as a second grip. And so this is where I think this law starts to get really dicey, because it's not just the normal features that you look out for in states like California, New York, and Illinois that have gone after assault weapons. That term, any second grip that could be used by the non-trigger hand, is incredibly broad and incredibly concerning. Now, they're going to do something nice for you. They're going to grandfather in all of the weapons that are owned prior to July 1st of 2024. And I should take a step back. They're also coming after, of course, pistols with a detachable magazine. Pistols with a detachable magazine that have a second grip, and they specifically use the term barrel shroud here. So what does that do? All of your MP5 types, your AR pistols, your Ruger PC Chargers, a lot of those weapons have a barrel shroud that you can hold on to, specifically going to become an assault firearm if this law were to pass. Now, as I just told you a moment ago, they're going to grandfather in weapons that are owned prior to July 1st of 2024. And presumably they're doing that because they think that is how they might be able to get the political support to pass this type of restriction. Keep in mind, The Democrats that are proposing this have a very narrow margin in the House and Senate. However, they'd have to get this through Governor Youngkin. And this is where I think gun owners need to really focus, because it seems pretty apparent to many in Virginia that Governor Youngkin has his eye potentially on the White House one day. And as he's looking towards what could be a path to the White House one day down the road, it is going to be critical for him to understand what the voting public does or does not want. And notably for Virginians, he has not been outspoken about his support for firearms. He's sort of not made a lot of statements about it. He hasn't done anything that would in a major way signal what he would or would not do. What does that mean right now? It means right now he absolutely needs to hear from Virginians so that he understands the public, the population, does not support these types of restrictions. So we need to be involved. We need to make sure that our voices are heard. You can do this by attending Virginia Citizens Defense League's Lobby Day, which is coming up in Richmond on Martin Luther King Day. Again, go to the vcdl.org website to check that out and get details. Absolutely, you should be joining gun owners there. Now, even if these restrictions were to pass, I think it is very likely that the courts would strike them down. And I think one of the reasons it's likely that the court would strike them down is because they obviously impact bearable arms. And if it impacts bearable arms, keep in mind, we get the Brune text, history, and tradition test where the burden gets shifted to the government, and the government has to show through historical analogs why the restrictions that they have in place are constitutional. And here what we are doing is we are drawing incredibly arbitrary distinctions between what firearms are legal and what firearms are illegal. These are so arbitrary that a firearm manufactured on June 30th and possessed in Virginia on June 30th of 2023 would become legal, and one manufactured on July 4th, right, Independence Day, would be illegal in the Commonwealth of Virginia. So arbitrary. I don't see how they would possibly get the founding era support to justify that distinction, let alone all of the other very arbitrary distinctions. And in fact, I think we ought to turn to what the Supreme Court has done on the subject of assault weapons, because the Fourth Circuit, which of course has both Maryland and Virginia, has already considered an assault weapons ban in the case of Colby versus Hogan. And in that case, they upheld the ban. It went up to the Supreme Court right after the Brune decision. The Supreme Court GBR'd it. They grant, vacate, remanded. So essentially, they took the case. They said, look, Fourth Circuit, you upheld this assault weapons ban. Wrong. Look at what we just said in Brune. Try again. That case was reheard, re-argued well over a year ago. We still don't have an opinion from the Fourth Circuit, but they can't delay forever. I think that they're going to have to strike down that ban. If they strike down that ban, that would, of course, hugely help us if any of these restrictions go into place in the future. Even if the Fourth Circuit doesn't issue their decision, we still have Virginia state courts to turn to. Virginia state courts, we have our own constitution in Virginia. We have seen some success arguing our own constitution in Virginia to strike down gun bans, notably with a case that my firm handled up in Winchester. So we could also look at the state constitution as a way to strike down these possible restrictions. Finally, I want to very briefly talk about another restriction that has been proposed that would restrict the carry of firearms in all restaurants that serve alcohol. Of course, right now it is illegal for somebody with a concealed handgun permit to drink in a public establishment that serves alcohol. This would make it illegal to even walk in, even if you're not drinking. I also think this is one that is very likely to be struck down. Similar restrictions have been struck down by district courts elsewhere. Even in Maryland, they have struck down a similar restriction. Again, there's not text, history, and tradition to uphold this. This one should not stand. That being said, it's better if we don't have to strike them down in the courts. It's better if we can keep them from being passed. I think that it's very important that Governor Youngkin and all the congressmen and senators hear your voices right now. Show up for Lobby Day. Join us there. I hope to see many of you there. Until next time.